Hello, and thank you for joining us for the Ask Andrew Show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the principal at the Greater Toronto Area family law firm, Feldstein Family Law Group. Both myself and the firm practice exclusively in family law in the province of Ontario. Today, our special guest is Cathryn L. She's a children's lawyer, a mediator, an arbitrator. Cathryn does some agency work for the Office of the Children's Lawyer. She's certified with the Ontario Association for Family Mediation as an accredited family mediator and a child protection mediator. She is also a certified mediator with ADR Ontario, and she's a certified specialist in family mediation and arbitration with the Family Dispute Resolution Institute of Ontario. Today, we're going to discuss the role of the Office of the Children's Lawyer. We're going to discuss about mediation, voice of the child report, and how someone like Cathryn does work to assist people who are going through divorce and separation regarding their children. Thank you for joining us today.
Hi, Andrew. Thanks for having me.
So first, I'm going to start with some background information on the children's lawyer. How does the Office of the Children's Lawyer become involved, and how would you end up involved to help a family?
Okay, so I act as an agent with the Office of the Children's Lawyer. What generally happens is that one parent will request the appointment of the Office of the Children's Lawyer through the court process. If the judge makes that order, then the request goes to the Office of the Children's Lawyer's intake department. And if they decide to take the case, then they will assign the case to an agent or one of their in-house lawyers.
Okay, now I've always found in my experience as a lawyer, and I've been doing this 25 years, it's always been a mystery to me why some cases are taken and some aren't. Some of them you get why, but most of them you don't. And I'm assuming it's probably a mystery to you as well. And basically you just end up that they request for you to be retained as an agent. Would that be a fair assessment of the situation?
Yeah, I don't see the cases that get rejected. I know that the cases that come to me tend to be fairly high conflict cases. There's a lot of dispute about what the children's views and preferences are, and often violence or other conflict between the parents.
Okay. Now, from my practice experience, I find that when people hear about the Office of the Children's Lawyer, before I talk to them about it, they really don't have an understanding of what the role is, what they're to do, and what has been your experience when you meet with a client in terms of what they're understanding your role is?
Well, when I meet with parents, often they really don't understand what my role is other than to speak up for the child. What I do and what I explain to parents is that I would meet with anybody who has an interest in having some time with the child. I do a lot of work other than just meeting with the parents and the children. I will get information from other sources, whether it's doctors, teachers, other people involved in the children's lives. I'm really looking for the overall context of a child's experience. I would meet with the children multiple times. And then after that, I would end up having a meeting with the parents and their counsel, if they have counsel, to talk about what the feedback is, talk about what position I'll take at court and why, and try to facilitate a discussion that hopefully may lead to resolution.
Now, when I think of the Office of the Children's Lawyer, when they get involved in my cases, one of the concerns we typically will have, and we were talking about this before the show, is what happens when you're talking to a child and the child says, I want to live with mom or I want to live with dad. How much weight do you give to that?
It really depends on a few factors. One is the consistency. I may find that a child really varies from time to time as to what they say. It may depend on who brings them in a particular day. It may depend on whether they've had a great weekend with one of the parents previously. So I have to look at consistency. I also look as to the strength of the child's conviction. Sometimes it's just kind of moderate views rather than really strong views. And I look towards whether I'm perceiving any influence from one of the parents on the child. And that could be something that becomes apparent based on the child's knowledge of the conflict, issues that they shouldn't be aware of, etc. So I'll look at all of those factors. I'll also look at other issues that are happening in the child's life in terms of what position I'm going to take. The position that I take certainly does incorporate what the child is saying, and I do certainly say what the child's views are to the extent that the child will allow me to share that information, but it's not necessarily exactly what the child is saying.
Okay, so I think there's a couple things that I heard in there as a message. Number one, is what the child tells you confidential between you and the child? If the child says, I don't want my parents to hear this.
Yes. If the child says, I want this to be kept private, then yes, that child is my client. As a lawyer, I have a duty of confidentiality to that client.
Okay. Now, the second area that I'll go to with that I heard about was we talked about the independence of the child and the child's views. I know I frequently will have clients phone me up and say, Andrew, my spouse is discussing everything with the child and they're trying to convince them to come and live with them. And I'm saying to the client, well, that's wrong. That shouldn't happen. You certainly shouldn't engage in that. And they're concerned about, will someone like you, who's from the Office of the Children's Lawyer, find out what the other spouse has been doing in terms of coaching the child?
Yeah. And that's a really common concern. And a lot of times parents are quite surprised about what they hear as feedback from the child's views. It's not always what they expect. It's not always what the child has said to them directly. Certainly one of the roles is to try to disentangle those threads if there has been influence. And that's why I would meet with the child multiple times. It's fairly, it's easier to determine that if I've had context and if I've seen the child in different scenarios too. I may meet with them at their home, I may meet with them at their school, I may meet with them at the office. I'm really trying to establish some consistency here, and it's very helpful in determining whether there's been influence to measure that child in different circumstances.
Okay, because I know that is always one of the things that I hear as a constant theme in a lot of my cases. The other thing that you hear from parents who are really concerned is they say, well, the child said they want to come and live with me.
Sure.
And I frequently say, well, the child may be saying the same to your spouse too.
Absolutely. Absolutely. No, and a lot of times I will hear from a child that they want to live with mom one day and dad another day, or I may hear from the child, I've told mom that I want to live with her, and I've told dad that I want to live with him because I do, and I don't know what to do. I'm stuck in the middle. So there may be times where a child really just doesn't even want to state their views and preferences. They want the parents to make the decision because they feel really caught. And this is something that comes out a lot in the disclosure meeting that I have with parents. A lot of times parents are really surprised as to what I say because the child has been saying one thing to them, and this is different from what they've said to the parent, because they feel that they can speak more openly to somebody who's neutral, who's acting for them rather than for acting for one of the two parents. They don't want to disappoint their parents. That's perfectly natural.
And that's a discussion I frequently have with my clients. And one of the other things you really try to impress upon clients is not to put pressure on the child, because
Right.
it's going to make them stressful. I mean, I could think of one case where the mother at a bar mitzvah wanted to have, she had her table and the father's table, and she wanted an empty chair at both tables so the bar mitzvah boy could choose where to sit.
Oh.
And
That's tough. I mean, you see that too with graduations, with all kinds of ceremonies, and you really want the focus to be on the child rather than on the conflict.
well, and that obviously is going to put an incredible amount of stress on the child, who then has to decide where he's going to sit or she's going to sit, and think about the timing. Like you said, graduation, all of these events, I can't imagine how stressful it is on the child, because I'm sure you've read about this, is the literature on the stress that these big events cause on the children, even as adults.
Yeah, absolutely. Absolutely. And what happens in childhood does continue very well into adulthood. Even when I'm acting as a mediator, I've mediated many, many files where the parents who are separating actually had their parents separate when they were younger, and that they really bring that pain of the their separation when they were a child into the separation as they're an adult.
And the strongest thing to try and get across to people is just that, is that you don't want the children to have that stress when they're adults. I know one friend of mine said he had to have a discussion with his mother at the time of his son's bar mitzvah because the mother had still refused to be in the same room as his father some 30 years after the separation. Yeah. And he felt like, as an adult, why do I need to have this discussion? It's 30 years later. And these are the things that people need to understand. Now, I'm going to change the topic a little bit right now, because what I think you've been talking and I've been talking about are more or less, I would call it the traditional role that you would employ as a working for the Office of the Children's Lawyer. And now there's something new that's called a Voice of the Child report that people are hearing about more and more. Can you explain what that is?
It's a little tough for me to explain in great detail. So I work as an agent of the Office of the Children's Lawyer. I'm not in there in-house with the Office of the Children's Lawyer. I personally haven't done Voice of the Child work. I understand that it's a new program that's out there, and my understanding is that it involves a more limited role for involvement of a professional, generally social workers who do the work, and that they would have a set number of appointments with the child and produce a written report that would be used in the litigation. I do Voice of the Child type work in a mediation or arbitration context, but the work that's being done through the Office of the Children's Lawyer, really my understanding of the goal is that it's to provide another avenue for a child's voice to be brought into the process in a way that's not as extensive as the traditional approach.
Now, it's my understanding, and correct me if I'm wrong, when we spoke about the traditional approach, you had the opportunity to meet a lot of collaterals. You had an opportunity to talk to the collaterals. You had several opportunities to speak to the child, to feel comfortable that what you were hearing were really the child's wishes. And it's my understanding Voice of the Child will not be nearly that detailed, and it's really expressing the wish of the child.
Yeah. And I can't speak to the specifics of that, as I haven't done that kind of work. As I said, my understanding is it is a more limited role. I don't believe that collaterals are involved, but I can't say for sure on that piece. Okay,
and when you've done it privately, have you had collaterals involved, or is it more one or two meetings with the child and writing a report based on what what's the child or children's wishes are?
So that depends on what the issue is. So if I'm doing a mediation, a lot of times if each parent has different views as to what the child wishes to have or what's best for the child, then I will involve either a social worker or other professional to meet with the children, meet with the parents, and then report back into the mediation. Sometimes they would involve collaterals and sometimes they don't. We define the scope depending on what the issues are.
Okay, because I personally have grave concerns with the Voice of the Child. I understand it's to get more people having access to services, but the problem is if it's simply the child expressing their views, then you run the risk of people wanting to put more pressure on the child to express their views in accordance with their wishes. And that's certainly not what is in the best interest of the child, because they shouldn't be pressured. Right. I don't know if you have any feelings on that.
Well, I think one of the goals of the Voice of the Child report is also to have an option other than a judicial interview for cases that don't have full resources through the Office of the Children's Lawyer. So there's always a concern about pressure on children. I would hope that the people who are doing that work will be very attuned to that, but it's always a concern when children's voices are brought into a process. You want to make sure that it's done in a way that's healthy and safe for the child.
Because I know I've had discussions on a few of my files about hiring social workers privately to do a Voice of the Child report. And what they seemed to indicate to me is that work didn't include any type of investigation as to whether or not the child's views were independent. And that's where I have just tremendous concern.
Yeah, and I understand. I think it's a matter of defining what that role looks like. So when I hire a social worker privately to do Voice of the Child work, we need to look at what is happening with this particular family. We need both parents to buy into it because it's a voluntary engagement. And we need to look, are there addiction issues? If so, then let's expand the scope. Are there educational issues? Let's expand the scope that way. So we really take time to craft what the appropriate process is. Again, that's if you've got parties who are willing to come to the table for a voluntary process.
Now, one of the other things I hear people ask me all the time is, at what age can a child choose where they live?
Right.
And what would you say about that?
There's no set age where a child decides where they can live. This is a really common misconception. I have kids come in and talk to me all the time who say, I get to decide where I live when I'm 12. I'll ask them, well, why do you think that? How did you hear that? That's not the case. Clearly, the older a child is, the more weight their views and preferences will have. But there is no set age unless you look at the age of 18 when somebody becomes an adult.
Well, I agree with that, but clearly you're 100% right when you say the older a child, the greater the ability they're going to have to choose, because it's hard to tell a 17-year-old where they're going to live, especially when they're bigger than both parents.
Absolutely.
And where they're going to go. Yeah,
no, and it's really hard. 16 and 17-year-olds, they're going to talk with their feet. They will do what they want to do, and it really imposes big challenges for the parents who are trying to discipline them, because as soon as they get something that they don't like in one home, they're going to be walking to the other home. So that's where parents really need to be on the same page.
Which can be very challenging.
Absolutely.
In high conflict. I see we have a question that just came in. What is the relationship between a children's lawyer and the Children's Aid Society?
Good question. Sometimes both are involved in the same file. Children's Aid Society gets involved where a child is in need of protection. A children's lawyer may be appointed to represent a child in a children's aid proceeding, or a children's lawyer may be involved in a custody access proceeding in the courts, where during the course of that proceeding there are child endangerment concerns, and so the Children's Aid Society may become involved even on a basis that doesn't involve bringing an apprehension proceeding to court, but they may be involved in the background working with the family. So if that's the case, then it's important that there be some dialogue between the children's lawyer and the worker on the file, so that the children's best interests are dealt with throughout. So the CAS is more involved in child protection, making sure that the child is safe, and the children's lawyer is more involved as an advocate for the child.
The other part of that question, they had a second part, was if the children's lawyer is involved, does that mean that CAS will be involved?
No, it doesn't. CAS will become involved if there's a child endangerment issue.
Now, what people do need to appreciate and understand is a few things. Number one, when you get a court order for the Office of the Children's Lawyer to be involved, you have to fill out an intake form and submit it to the Office of the Children's Lawyer in order for them to consider it. And one of the documents in that form will require you to sign an authorization and direction for CAS to release their file to the Office of the Children's Lawyer. So if you've been involved with CAS, the Office of the Children's Lawyer will want to know about it and will be able to have access to your file.
Yes. Yeah, but that's part of the collateral information that we would seek as a children's lawyer as well, is write to the relevant children's aid societies and inquire whether there's been any involvement.
The other thing that people need to appreciate is that when you do get the Office of the Children's Lawyer involved, that opens the door up to both of your lives to a third party that is a quasi-government agency. And if they feel that one or all of the children are in need of protection, they will report the family to Children's Aid.
Yeah. And that can be a thorny issue, but anybody who's involved with the family who suspects that the child is in need of protection would have that, would do that as well, right? So whether it's somebody through the Office of the Children's Lawyer, whether it's a teacher, whether it's a counselor, that is always out there. So it's not something unique to the Office of the Children's Lawyer.
Okay, now we have another question. Can legal aid help me pay for a children's lawyer? And I think what we said at the beginning was, and Cathryn explained this, was that the children's lawyer gets appointed by virtue of a court order.
That's right.
They're a government agency.
That's right. So there is no charge to the parents for the work that the children's lawyer does. As an agent of the children's lawyer, I submit my invoices and I get paid by the by the Office of the Children's Lawyer. So it's not a cost to the parents. I find a lot of times we're extremely helpful in cases where both parties are unrepresented, because a lot of times my work becomes really important in helping them resolve disputes because they don't have the lawyers there who can help them do that.
I would actually say, as a lawyer, when we do get either the disclosure meeting or B, the report, it becomes very helpful at resolving the case, because depending on what's said, that's when, as a lawyer, I have to have sometimes a really difficult discussion with my client. The client has to understand there's a very big uphill battle that they're going to need to overcome, because the social worker is the only independent person without a bias who is given recommendations. Yeah. And unless you can show there's problems in the way they looked at the case and in their findings and in their recommendations, you have a big challenge ahead of you.
Yeah, no, absolutely. And it is tough because lawyers will hear from their own clients what the client's perspective is of the situation. And it's a very different analysis that the lawyer or the social worker goes through. I do want to distinguish between the two kinds of roles, if I may. Office of the Children's Lawyer could appoint a social worker, and that would be under Section 112. And in that case, the social worker will do a full investigation and make a written report. Whereas how I get involved is as an advocate. I don't do a written report for the court. I appear at all of the court appearances and work with the families until a final resolution.
Now, what people need to understand when we distinguish between the two types, the Section 112 and the Section 89, is in either case, when you get to the disclosure meeting, it's very, very helpful at getting to a resolution. And when you are facing a Section 112, which you don't do the Section 112s, I regularly will say to the client, if the Section 112 at the disclosure meeting is where you get an oral explanation of their findings and an oral list of the recommendations, and if it's really bad, you're quite frequently better off to make the best deal you possibly can. Because if you force the writing of a written report that's going to be negative, that's going to be there for all times. And that means that if in 2 years or 3 years you think there's a material change and there should be something that's a change, even though that report may be dated, if it had all sorts of negative findings about you as a parent, you really don't want that negative findings to be out there in an affidavit that the judge making the decision will be able to read. So you really have to be mindful, because if you're hearing a negative case and a negative position, it can be very hurtful, especially with young children, for a future go around that may end up happening. So that becomes problematic. Now, we haven't talked much about your mediation, but I wanted to ask you, what type of mediation work do you usually do?
Oh, I do all kinds. So the majority of my practice is mediation. I work with parents doing parenting mediation. I do comprehensive mediation involving financial situations, what complex or not. And in the parenting mediation, we look at what's the best way to deal with situations if the parents aren't agreeing. And so that's, sometimes I will meet with the child in that circumstance. Other times I will have somebody else, a social worker. I've got a few that I work with regularly who will do that work and report back.
And why is it that you would hire a social worker instead of meeting with the child yourself?
It depends on the circumstances. Certainly if there's a situation where I want to have a more comprehensive involvement, and I'm worried that if I take the position on behalf of the child, I'm going to compromise my role as a mediator. That's where I would want to have a social worker involved. More often than not, I will have the social worker involved so that it's something that is a more distinct process. The social worker will then come back in and work with us in the mediation as to what the appropriate parenting plan may be. If it's a situation, I've had cases where the parents have said, my child will not meet with the social worker. They've turned down counseling completely. They refuse to do that. Then that's where I may look at meeting with the child myself. But generally not if it's going to be a really hotly contested parenting situation.
Now, would that be in Med-Arb or
No.
mediation?
If it's Med-Arb, I would have a social worker meet with the child. I don't want to have that role confused. I want to make sure I've got somebody else who can give evidence as to the views and preferences of the child.
Okay, to me that makes a lot of sense. I hope the viewers understand that. Now, you said you do a lot of mediations. Would you say the vast majority is about parenting issues, or would you do a lot with property and support as well?
It's all mixed, and most families who come in have all issues. They've got kids, they've got support, they've got property to deal with.
Now, when you deal with mediations, do you usually just have the parties there on their own, or do you have the lawyers present?
It depends. I'd say probably about 70% of my cases are with the parties alone. 30% are with lawyers. And of the ones that are the parties alone, sometimes that morphs into a mediation with lawyers. It may be that we deal with the parenting issues with me and the parties, and then the financial issues, the parties will have the lawyers there to assist them.
Okay, because I find for a lot of people, they're considering they want to go to mediation. There's always, they think one person is going to have an advantage if they called, or one person picked the mediator and established a rapport based on a phone call. What are your feelings when you hear that type of commentary from prospective clients?
Oh, I hope it's not my office. What I have is parties call in and they speak with my assistant. I don't speak with them directly at first call anyway. They fill in intake forms, and then I would meet with each of them individually for a first session, a screening session, to see if mediation is appropriate in the circumstances, to talk about their goals in the process, to talk about what my process looks like. And then following that, we would look at a joint session. And in the individual sessions, we may then decide it makes sense to do this with lawyers, or let's start without lawyers for now and see where we go. But I really put no stock into who calls first or who is more in favor of mediation than the other.
Okay, now are your mediations always closed, which means what's said at the mediation stays in the mediation and can't appear in court, or do you ever do open mediation, which would allow that to be before a court?
So my default is a closed mediation. I find that people are more willing to be creative in those mediations, to put out some offers that they may not want to have a judge impose. But I'm certainly willing to do open mediation, and I have done open mediation in some circumstances. I also find generally lawyers prefer to have closed mediation because they're not sure exactly what the client's going to say in mediation, especially if they're not there.
Well, that's always a concern of an open mediation, but sometimes some people also like the idea of an open mediation because they think the other side will say the things that they're hoping they're going to say when the lawyer isn't present, and to have the mediator reflect that. Whether that turns out that way is a different story. Right. But as a lawyer, it's always good to know which mediators are prepared to do open, because some don't want to do open mediation because they're worried about potentially being called as a witness at a hearing. So obviously that doesn't bother you.
Well, I do open mediation. I do have as a term of my agreement to mediate that I will not be called as a witness in a hearing. Now, that still may happen. I may be called at some point, but that's what I would do in an open mediation, is to write a report setting out what was done at the mediation rather than appearing in court. If I get called in court, then we'd have to deal with that.
Okay, now we have one question just came in before the end of the show, which is what happens if the alternative party refuses to pay their half of the mediation fees?
Yeah. Well, the way I run my practice is each party pays at the end of each session. I have built into my agreement to mediate that the parties will share the costs of the mediation equally, unless otherwise agreed in writing. So there are some situations where we will agree to one party paying for all of the costs, or splitting it to 25-75, depending on the circumstances. If one party fails to pay for their share of the mediation, that's an issue that I'm going to take up with that party, and I'm not going to continue to mediate unless that is satisfied.
Now, there's a big difference before we finish it between mediation and arbitration, because in mediation, if somebody doesn't pay and they're not interested in mediation, well, you can't force them to the table.
Right.
But arbitration is where you would be entitled to make that final decision and that final call. And somebody might think a hearing isn't going their way, and they don't want to make that final payment to try and stop you from making a ruling that they think will be against them. What would you do in that circumstance?
Yeah. That's a really tough issue. I mean, certainly I have the ability to withhold my award until final payment is made. With arbitrations, I will take a retainer up front, and I will make sure that that retainer is going to be sufficient to get through at least the bulk of the work involved. I also have the ability to reapportion costs, so that if I find one party has been unreasonable, that I could make the awards such that the other party is the party that's been unreasonable bears more of the costs of the award. I also have the provision so that if one party chooses not to continue to pay as they're supposed to, the other party may pay that amount and seek reimbursement of that as a costs award.
So in other words, they can't stop the arbitration from being completed by not paying.
That's right.
Okay,
the arbitration will go ahead.
Okay, now I see that we have run out of time, so I wanted to thank you for being on the show today. It was a pleasure having you. And for anyone interested in learning more about Ms. Paul and her practice, you can visit her website at oakvillemediation.com. That's an easy one to remember. And the next Ask Andrew show is on November 13th, 2018 at 1 p.m. If you have any requests or show ideas, please email them to us at info@feldsteinfamilylaw.com. And thank you for watching.